Hi, everyone, and welcome to another question and answer session live. My name is Samara Belitzky, and I'm a lawyer with Samfiru Tumarkin. I'm actually working out of our Ottawa office, but I'm here to answer all of your questions, whether you're in Ontario, BC, Alberta, whatever the case may be. I'm here for the next half an hour to answer all of your questions related to employment law. I'm also able to answer any questions you might have related to disability law or benefits, as well as workers' compensation. So if you have any questions about severance, terminations, changes to your terms and conditions of employment, issues with health and safety in the workplace, whatever the case may be, any questions you might have, send them in now. And now is the time. As I said before, I'm here for the next 30 minutes or so to answer all of your questions. So I will wait for you to start sending them in. In the meantime, as always, I have a few things to discuss that have come up either in the news or we've been getting a lot of questions about these things in the last couple of weeks. So the first thing that I wanted to talk about is what's been in the news for the last week or so, which is Nordstrom. So as most of you watching will know, Nordstrom has essentially declared bankruptcy. They're closing all of their stores in Canada, Nordstrom stores, Nordstrom Rack stores. They're closing everything as of this summer, essentially. And what's very particular about this situation is that Nordstrom has actually gotten what's called creditor protection. And so whenever we're dealing with companies that are shutting down, it does happen sometimes. Nordstrom is no exception to what we see sometimes with companies shutting down or going out of business. But when an employer gets creditor protection, when they're declaring bankruptcy and they get that bankruptcy order and the creditor protection from a court, it then allows them to essentially get out of paying regular termination pay or severance pay that they would normally have to pay if they didn't have that creditor protection, if they didn't declare bankruptcy. So this is something that I get a lot of questions about that I thought would be really helpful for people to know is, we're talking about Nordstrom specifically, but generally speaking, when you're dealing with a company that says they're going out of business or they're closing down the business or the operations, or maybe it's a store or a restaurant and they're closing it, there's a difference between saying that you're closing down, you're closing the store, you're closing the operations versus actually declaring bankruptcy. And the big difference is when it comes to severance and termination entitlements. So as I just mentioned before, when we're dealing with a situation like Nordstrom, for example, where they have gotten that creditor protection, unfortunately, what's going to happen is the employees who work for Nordstrom are likely going to be receiving working notice. They're going to be receiving notice of when their last day will be, and that will hopefully allow those employees to find another job sooner rather than later. But when it comes to any other kinds of severance entitlements, actual money being paid out, that's where those employees are not going to be able to pursue that under the regular, legal recourse mechanisms that would be available. Now, if a company has not filed for bankruptcy, they haven't received creditor protection, then from a severance perspective, it's fair game. Meaning if you're an employee, you've been let go, you've been told we're shutting down the company, we're slowing down operations, whatever the case may be, however they say it, you would still be owed your full severance, your full termination entitlements. And so we often deal with companies where they've shut down a part of the business or they've shut down the whole business, but the corporation is still active. They haven't declared bankruptcy. Maybe the owner of the company is retired and doesn't want to run the business anymore, whatever the case might be. That company, that employer is still liable for paying the employees their full severance and for providing them with their full termination entitlements. And so in situations where that happens, you absolutely should be pursuing your full entitlements, and you should be doing it right away. The reason for it is, generally speaking, time is always of the essence. We want to make sure that if you're pursuing your termination entitlements, if you're going after more severance, you want to be doing that as quickly as possible. You don't want to wait longer than you need to. But especially in a situation when the company is shutting down or possibly declaring bankruptcy, you really want to move quickly on these things, because it may be that If you're able to communicate with the employer quickly, it's possible that if they're going to declare bankruptcy, maybe you're able to get a severance package before they do that. Either way, it's important to make sure that you speak with an employment lawyer and that you move forward with these things very, very quickly before you possibly lose the opportunity to do something about it. And so anytime you're being told your company is shutting down, don't listen to what the employer might be saying, because oftentimes the employers themselves are not aware of how the law works, or maybe they are aware, but they're telling you the wrong thing. In any case, you have to do your own due diligence as an employee in a situation like that. Contact an employment lawyer. You can always contact us at help@employmentlawyer.ca, and we can discuss the situation and see what it is we can do. Unless and until a company has declared bankruptcy, unless and until they have creditor protection, from a legal perspective, they're still liable to pay your full termination entitlements. So that's really important to keep in mind in terms of making sure you get what you're owed as an employee if you find yourself in a situation like this. Now, the other thing, we have a few questions coming in. I'm just going to finish on this point. There is a program that is administered by the government that's called a wage protection program. That is a situation, or that would apply in a situation where your employer actually has declared bankruptcy and you haven't received your bare minimum entitlements under the employment standards legislation in the province in which you find yourself. Excuse me. So what that means is that you have a very specific amount of time from when your last day is, when your termination occurs, in order to file for this type of claim. It has to be within several months of the termination. But if, let's say, you're let go and you don't receive any notice of your termination of your last day, or you do maybe receive something, but it's not quite what you're supposed to receive as your bare minimum entitlement under the Employment Standards Act in the province in which you work, then you can file this application, this claim with the government for the Wage Earner Protection Program, and you will be eligible to receive your bare minimum entitlements under the Employment Standards Act. So unfortunately, if there is a bankruptcy, you wouldn't be able to receive your full severance, not from the employer, not from the government, but there are situations in which you can file with the government to receive just your bare minimum entitlements if you haven't received that. So that's something to keep in mind as well. If ever you are in a situation where your employer does declare bankruptcy, you can't pursue your severance from them, there is this alternative. It's not the ideal situation, but it's kind of the next best thing. So I'm going to pause now and get to some of the questions that we've received. I have a question from G.O. on Reddit, who asks, what can you expect when filing a constructive dismissal complaint under the ESA? How does it work? So when we're dealing with a constructive dismissal complaint or argument, what's really important to know is what is a constructive dismissal. So first off, a constructive dismissal is something that occurs when an employer makes a significant change to the fundamental terms of employment. So it's not any change that would rise to the level of a constructive dismissal. It has to be a permanent change, and it also has to be significant. And so certain changes will not necessarily trigger a constructive dismissal, but others will. For example, if your employer is reducing your pay by 30%, forcing that change on you, you have no choice. They're just reducing your pay by 30%, and too bad. In that situation, that would be a constructive dismissal. If, for example, an employer is changing your work location such that you're now going to have a 2-hour commute, whereas before it was half an hour, that also would be a constructive dismissal because it's a very significant change to one of the fundamental terms of your employment. And so when we're dealing with constructive dismissals, more often than not, you're going to be dealing with the common law, with your full severance. So the question was with respect to a complaint under the ESA, the Employment Standards Act. Now, certainly as an employee, you do always have the claim available to you to be filing a constructive dismissal claim under the Employment Standards Act and going through the Ministry of Labor in the respective province that you're in. However, I do not recommend that you do that if you're in a situation of constructive dismissal, because if you're successful, you file a complaint with the Ministry of Labor, they find that you were constructively dismissed and you're owed your severance. The Ministry of Labor can only get you your bare minimum when it comes to severance. So you would only be able to receive the bare minimum entitlements that are outlined by the Employment Standards Act. And so you wouldn't be getting all that much depending on your length of service. Conversely, at common law, when we're dealing with your full severance and you're going through the court system, that's where, as an employee, you can actually secure your full severance, which is generally a lot more than what your bare minimum entitlements will be under the Employment Standards Act, under the ESA. So if you're ever in a situation where an employer is making changes, the first thing you have to do is speak to an employment lawyer, find out, A, are they allowed to make these kinds of changes? And if not, B, what are your options for legal recourse? There are different things that you can do. If it's a situation where you want to keep working there, but you just don't want the change being proposed to take place, there are ways in which we can assist you in addressing that. Otherwise, if it's a change that's going to be going ahead no matter what, and there's no use in even having discussions with your employer, then you may decide to right away go forward with pursuing your severance. So there are different options and there are different avenues depending on the situation, depending on what the change is that's being forced on an employee, depending on what you want to do, what your goal is as an employee. But the first step is getting legal advice, doing your due diligence, speaking to an employment lawyer to figure out what's what, and then you move forward. Certainly, you always have the option of doing the complaint under the Employment Standards Act with the Ministry of Labor. The benefit to doing that, and I'd say the only benefit to doing that, is that it is a free process. You don't need a lawyer for it. However, that kind of advantage is far overshadowed by the fact that if you're successful, you only get your bare minimum. And in some cases, that can be an extremely significant amount of money. It could be the difference between a year of pay or 8 weeks of pay, just to give you a quick example. So there really can be a very, very significant difference there. And what's important to keep in mind is if you do file a complaint with the Ministry of Labor for constructive dismissal, for severance, you're then stuck with that process. So you can't go to the Ministry of Labor, file a complaint, and then after that, once you get your minimum entitlements, go after your full severance with a lawyer. You cannot do that. You have to choose one process or the other, either the Ministry of Labor under the Employment Standards Act or with a lawyer going after your full severance. And we would always recommend going for that second option because you could be owed so much more than what you'll be able to get with the Ministry of Labor. So if you're ever in a situation like this, definitely speak with a lawyer first. You can go to our website, employmentlawyer.ca. You can email us at help@employmentlawyer.ca, and make sure that you speak with a lawyer and find out what your options are before you do anything. Because again, once you file with the Ministry of Labor, if you do assert a constructive dismissal claim under the Employment Standards Act, you're stuck. You're stuck with that process, and then you won't be able to get more than your bare minimum. So you have to be very careful in the way that you proceed there. I have another question from Art on YouTube who says, my uncle was just told that he's being moved to a new position after 20 years with the company. What can he do about this? He took a personal day but doesn't know if he should go back. So the first thing is, in terms of what your uncle should do right now, is he should get in touch with us right away. He can contact me directly. My contact information is on our website, employmentlawyer.ca. He can email me. He can contact me directly. Otherwise, he can contact our firm and he can be connected with one of our employment lawyers. And what he should be doing is, if the change hasn't happened yet, you mentioned that he's being moved to a new position. If it hasn't happened yet, he should be going to work. There's no reason for him not to be at work if the change hasn't happened yet. Okay. If the change has already happened, then even more reason to urgently get in touch with a lawyer to figure out what to do next. I always recommend that in a situation like this, you speak with a lawyer first before doing or saying anything. Ultimately, your uncle will have to outline the fact that he refuses the change. If it's a completely new position, if it's unrelated to the position he was already doing, and he doesn't want to do this new position, that would be considered a very significant change, and it would likely amount to a constructive dismissal, meaning he can refuse it, but he has to do it in a very specific way. And so usually in a situation like this, we would be able to help guide your uncle behind the scenes in terms of what to say and how to say it. But he will need to refuse it, and he will need to do that in writing. So there's a very specific process that needs to be followed. So tell him to get in touch with me or our firm right away so that we can assist him, because time is really of the essence. Whenever you're dealing with a possible constructive dismissal, with a significant change that's being forced on anybody, you have to act quickly, and you have to move forward and speak with a lawyer as quickly as possible. Because if you don't, and let's say you keep working under the new changed terms of employment and you keep working under those terms for a few weeks, and then you decide that you're not happy with it and you don't like it, it may be too late. At that point, it could be what's called a deemed acceptance, where even if you haven't said out loud or signed anything saying you've accepted the changes, you could be deemed to have accepted them just by the fact that you keep working under those new terms and conditions of employment. So you have to be very, very careful with that. In this case, it sounds like the change hasn't happened yet. If it hasn't happened yet, he can keep working until it does. But he should get in touch with us right away so that we can advise him on how best to move forward. Again, if the change has happened already, then he needs to be careful of not continuing to work under those changed conditions. And so he should be taking, a personal day, as you call it, or a leave or a vacation day if need be, in order to speak to a lawyer and figure out what he's going to do next. I have another question from Carter on YouTube, who asks, how long does an employer have to hold a job for someone on sick leave? Generally, there's no limit to this. So if somebody is on sick leave, is on medical leave, as long as an employee, you substantiate that with a note from your doctor outlining the fact that you're unable to work for medical reasons, your employer does have to hold your job for you. Now, when we're talking about holding the job, that doesn't mean that they can't have anybody else do your job while you're on medical leave. While you're on medical leave, the employer is allowed to replace you temporarily. They're allowed to have other employees do the duties that were associated with your job. They are allowed to make arrangements while you're away from the office or away from the workplace. Once you're cleared to return to work after your medical leave, the employer has to put you back into the same job that you had prior to your medical leave on the exact same terms and conditions that applied when you went off on medical leave. So in other words, holding your job, doesn't necessarily mean they have to put it on hold. They can have other people do your job while you're away, but it does have to be made available to you when you return, as long as it still exists. So for example, sometimes I've seen situations where somebody's off on a medical leave or a parental leave for a year or longer. And by the time they go back to work while they've been away, the employer has undergone a restructuring. So they've changed some positions, they've eliminated some positions, and it may be that when you go back from that leave, your job doesn't exist anymore. In a situation like that, the employer actually has to put you in the next most comparable job, as long as there is one. If there's a comparable job that exists, then that's what they would have to provide you with and put you in when you go back to work. If, let's say, there is no comparable position available after a restructuring, then the employer may be in a situation where they would give you the option to either accept a job that's not comparable, in which case you would have the choice of whether you want to accept that or not. And if you don't, then you would be owed a severance package and you'd be owed your full severance. In terms of how long someone can be on medical leave for, there really is no written or law with respect to how long someone can be on medical leave. Generally speaking, what's important to know is that sometimes if somebody's on medical leave for a very long time, 2 or 3 years, and maybe this person has no prospect of ever returning to work. If there's a very serious injury or medical condition where you know for sure you're never going back to work, or you're never going to be able to go back to this particular job or this particular employer for medical reasons, in scenarios like that, there is a principle of law that applies that's called frustration of employment. So if, let's say, you're in that situation, which doesn't come up all that often, but sometimes it does, and you're on leave for a long time, your employer can check in with you and check in with your doctor to get an update on whether you may be able to return to work, and these are the magic words, in the reasonably foreseeable future. So if ever you're on a medical leave and you receive a questionnaire from your employer that they want your doctor to fill out, or they're asking questions and you see any questions about when you might be able to return to work, you see any questions about the reasonably foreseeable future, that's kind of a red flag where you know that the employer may be contemplating asserting frustration of your employment. And so anytime you're asked to provide an update, if you're on a medical leave that's lengthy, anytime you see, a questionnaire that has those types of questions, it's really important to get legal advice from an employment lawyer before you have your doctor fill out those forms. I've seen it too many times where an employee has been on medical leave, they've had their doctor fill out their forms, their doctor might not have filled it out in a way that would put them in the best legal position. And then the employer says that they are letting the person go for frustration of employment based on what the doctor said in the questionnaire. And after the fact, it's very difficult to refute what the doctor has said in the questionnaire or how it can be interpreted in many ways. So it's hard to kind of put the genie back in the bottle after the fact. And so if you're ever in a situation like that, definitely get legal advice before you respond, before you have your doctor fill out the questionnaire, so that you can make sure that you're in the best situation possible moving forward, of course, from a legal perspective. Now, if it truly is the case from a medical perspective that you're not going to be able to go back to work, maybe ever, but at least for a long, long time, then your employer would have the ability to assert frustration. And what that means is they would terminate your employment for frustration, meaning it's no fault of yours, it's no fault of the employer's, but unfortunately, because of your medical condition, you're unable to perform the job that you were hired to do. And so if you're on an extended medical leave and it's clear from the medical documentation you cannot return for a long time or ever, the employer can do that. They can let you go for frustration. And what you would receive at that point is your minimum entitlements under the Employment Standards Act in the province in which you work. And so you wouldn't be entitled to your full severance in a situation like that because it's a result of your medical condition, unfortunately. But you are entitled to receive your minimum entitlements, your bare minimum entitlements under the Employment Standards Act in a situation where there truly is frustration. Okay. Moving on, I have a question from Peter on Facebook who asks, what are the rules/laws about bereavement in Ontario? So there are certain rights that employees have, which are outlined in the Ontario Employment Standards Act. So in order to know what kind of your bare minimum rights are for a bereavement leave, they are found in the Employment Standards Act. And you are entitled to have time off in certain cases where there are certain deaths in the family that take place. So that's with respect to the Employment Standards Act. However, there are some employers who actually have their own bereavement policies. So your employer may have its own policy when it comes to that. So if that's the case, that would actually supersede the Employment Standards Act. So if your employer has a policy on bereavement that is something that provides you with more than what's in the Employment Standards Act, then that's what would apply. The other thing to keep in mind is that's only something that applies if you're not unionized. If you're unionized, then your collective agreement will have a provision about bereavement leave, and that's what would apply. Oftentimes, if you are a unionized employee, the provisions in the collective agreement with respect to bereavement leave will be quite advantageous, especially compared to what the minimum in the province might be. And then, of course, if you're federally regulated, you wouldn't be looking at the Employment Standards Act. Even if you're in Ontario, if your employer is federally regulated, you'd be looking at the Canada Labour Code for the minimum bereavement provisions. And if you work for the federal government, for example, and you're unionized, the collective agreement is where you would look. And I happen to know that in a lot of unionized workplaces, those provisions are quite significant. And oftentimes you would have, for example, a week off work paid. But again, that's with respect to a lot of unionized workplaces. Non-unionized workplaces, your starting off point is the Employment Standards Act, or a policy that your workplace might have in play. The other thing to keep in mind with respect to your question, Peter, is if, let's say, you do require time off, maybe you've taken time off for a funeral or for a visitation, but you may be affected, from a health perspective by the death, you could then take further leave and provide a doctor's note. So if you do need time off, and perhaps it's with respect to a mental health issue, and you need to kind of collect yourself and kind of take some time to yourself, you can go on a medical leave. And as we just talked about, those can go on indefinitely. The hope is that that wouldn't be required. However, if you need some time off of work, and you can provide a note from your doctor that says that essentially it's for medical reasons, even if it might have been triggered by the death of a friend or a family member, then the employer does have to accommodate you and does have to allow you to take that medical leave. Again, as long as it's supported by a doctor's note. I'm just reading the next question that I have because it's been asked over a few different messages. So just bear with me here. So I have a question from Dale on YouTube, and Dale, I appreciate that you've provided a lot of information, but it's difficult for me to assess whether your situation is a constructive dismissal or not, because I don't have all of the information of what your job entailed prior to your medical leave. So Dale essentially is saying in his question that he went on a long-term disability leave, and now that he's come back to work, it looks like there's been some changes to your role and to your duties. Which generally speaking, if they are significant changes, those are not things that you need to accept. If the employer is implementing changes to your role, if they're changing your duties, if they're taking away a significant portion of your duties, if let's say you were in a managerial role and you're no longer in a managerial role, these are the types of things that could constitute significant changes and result in the ability to claim constructive dismissal. But I would have to review this situation in further detail with you, because we have to look at what does your job look like now compared to what it looked like before your leave. And if there are those significant changes that we've talked about, seems to be kind of the theme for today is constructive dismissal. But if there are those changes that we've talked about throughout this session, and they are significant, then certainly there are things you can do, and you may be able to claim constructive dismissal and pursue your severance. There also could be a human rights claim here, because if your employer is treating you differently because of your medical leave and because of your disability, that could also be discrimination under the human rights legislation in Ontario, the Ontario Human Rights Code, for example. So you can get in touch with me directly, Dale, or you can just contact our firm, whatever works best for you. But you should definitely get advice from an employment lawyer on this right away, especially because it sounds like this has been going on for at least a couple of months. And as I mentioned before, when we're dealing with constructive dismissal situations, time is of the essence. You need to act very quickly. If you've continued in the role for months under these changes, it may be too late. You may have already be deemed to have accepted these changes. So get in touch with us right away so that we can assess the situation for you. And if there are legal recourse options available to you, we're more than happy to assist you moving forward. So that's all the time we have for today. Thank you everyone very much for sending in your questions. We do have another session next Tuesday. So if you did have questions that didn't get answered today, please tune in next Tuesday, and my colleague will be able to answer your questions then. So I will be signing off now, but thank you all for your questions, and I hope that everyone has a wonderful weekend.